Okay, as far as you may notice, I will talk about IP and autonomous vehicles, and I need a pointer here. Okay. So it's very comfortable to start with a quote, especially when you're quoting anonymous, so no one takes responsibility for that. But this is actually how it looks like when it comes to IP and autonomous cars. So we have old problems that haven't been solved yet, and now they're coming back in a new context. So there's another quote, like most people spend more time and energy going around problems than in trying to solve them. Natalia kind of reminded me, I have only 10 minutes, so I will also going around problems instead of solving them. And I guess that this is probably no accident that Henry Ford is the author of this quote, who's very important in this business. Let me just briefly explain you. When you go through any legal text, autonomous car is the highest possible level of automated car. Is this a new idea, autonomous cars? Well, not really. Here you have the concept that was introduced in 1939, so a pretty long time ago. As you can see here, we have a city with no lanes, no traffic lights, just autonomous cars on the roads. I will just show you today that the IP considerations are at the very, very end of all the problems connected with the legal aspects of autonomous driving. So that's why I would like to compare a little bit the US case and European Union here. As you can see here in United States, many states already enacted autonomous vehicle legislation. Of course, it does not say nothing at all about IP. It focuses on public issues like what do you have to do so your car could be tested on a public road. What about insurance, whether there is a special sum of insurance that you have to cover at the entrance. And this is the last quote I'm going to use. Well, the only real available thing is intuition, but actually when it comes to law, not really. You've already saw that in US, they already deployed lots of legal documents about how autonomous cars are supposed to work. How it looks like in European Union, well, very, very intuitive. As you can see here, we have 5 levels of cars being automated, and here, as Natalia mentioned, in European Union, even though we have no legal framework, there is one document from April 2016 that enhances the states to, start any kind of cooperation, but we don't have any legal document, so I guess that this is only intuition. But as you can see here, by 2028, it's going to be autonomous cars on the roads, according to European Union predictions. In US, they already deployed the courses for the future lawyers, legal aspects of autonomous cars, but they don't focus on IP at all. These are just public issues, cases with the accidents, how to deal with the responsibility and liability. And how it looks like in European Union, we have the special agenda within the European Commission. And when they talk about autonomous cars, well, when I, as a lawyer, see vehicles, equipment, hardware and software, I already see lots of IP problems. And of course, it's going to change and transform our transport and mobility patterns. But the question is, will it change any kind of patterns of IP protection as well? This consideration right now is out of question. So I will just briefly go through 3 issues: freedom to tinker, software patents, and what really matters. And what really matters is what is actually really a true problem when it comes to practice, when it comes to impose all these exclusive rights. Freedom to tinker. I would risk saying that under most jurisdictions there is no such thing as free use or fair use or any kind of permissible use when it comes to software, what was mentioned just a minute ago. You are not allowed to check how it works, regardless the purpose. And what the industry says about freedom to tinkering when it comes to car software, well, no. Why? Well, users might circumvent in order to avoid restriction on vehicle emissions imposed by the law. And the second argument is potential adverse effects on the safety and the environment. This is what industry says, and this is what industry does. And I guess that doesn't require any further comment. The last line was added like recently, that probably that would be the solution to this case. And there's another example, because there was another argument about safety reasons. So this is how it looks in practice. There's no freedom to tinkering. Recently, in the US, they started to notice that maybe it went too far, especially when you take care of safety issues. So they introduced some kind of exception to DMCA, but it's limited to a certain kinds of software that you have in your machine. And it's introduced, as far as I'm informed, for about 3 years to check how it's going to go with the environment, whether this is really needed, how it works, but I haven't heard about anything like that in European Union. They don't think about enlarging this freedom to tinker. What about software patents? Well, this is a very complex issue, but probably most of you know that patents are not supposed to be granted for software, regarding whether it's American law, European Union law, state legislations. But the problem with software patents is that they usually come in disguise in kinds of computer-implemented inventions or anything else. And that was the practice, the usual practice, that the applicants wanted to convince the patent office that they actually want to have the patent over something else than software. What's happening right now is, this is very, very rough search, so this is not like 67 results for the patents in automotive industry, but the thing is, they don't use this Halloween costume anymore. They go strictly to European Patent Office for patent for computer program. And when it comes to automotive cars, there are plenty of that kind of patents. Well, of course, you may say that it's not software makers, but automakers lead in driverless car patents. But the truth is, they cooperate with these companies. And what do you think they do for them? Well, probably something like software. So this is the real issue when it comes to patents. And how it looks in practice, this is a very old issue, old problem. This company, Cruise Control Technologies, they obtain a patent for a very frequently used technology. And as you can see here, we have the pure trolling case. You can see who defended where in this disputes. There are more defendants. And the very important information is that the cruise control does not use this technology itself at all. Okay, so what really matters, how it looks in practice. Do all these owners of autonomous cars technologies use these copyright exceptions? Do they use these software patents? This is what really matters. Mr. Lewandowski, but not this one. I mean Mr. Anthony Lewandowski, the former CEO of Waymo, which belongs to Google. I don't know if you've heard of the dispute, but what happened here is also very, very old issue. Mr. Lewandowski stole 14,000 confidential documents from Waymo, and then he started work for Google. And what does Waymo do? Well, Waymo sues Uber. And what are the bases for the lawsuit? Well, you may think copyright, well, no freedom to tinkering. You may think of patent law because they had lots of patents for this technology. But no, they just go for trade secrets and confidential information protection. Why? They decided that this is not very convenient for them to use all this patent protection. So the question is about IP patterns of protection. Is it really needed in this form that we had it right now? We know that Tesla has some different ideas for that. What also was said here, that suing someone over infringing the patent, well, this is not the true ethos of Silicon Valley. You're not supposed to use it in an offensive way, because this is against all the ethos. But here, well, it's not so clear whether it's offensive or defensive here. But the truth is, Waymo had all these patents. The judge advised them, don't go through patent protection. It's going to take too long. You don't have the true evidence. You don't use it. Just go for the trade secrets. And these all IP problems, there are lots of them. But think about that, how it's going to look like in the European Union. We don't have the legal grounds for allowing these autonomous cars on the public roads. As you could see in none of the documents that I went through, they say about IP. So it's at the very, very rare end of the considerations. So even though the problems are very well known, we are still driving into the unknown. But according to the European Union, within 10 years, we're going to have lots of autonomous cars on our roads. Okay, thank you very much for the attention.